Thank you for your kind introduction and invitation to deliver a talk on one of my favorite topic, which I deliver for last 15 years or so. And you can see this, the tagline I have intentionally added. I was told only for consent, and in your brochure also you can see is only consent. And we have added from our side, means whether it is an essential accord or savior. Means this is a dilemma. Kakade sir is here, he was in Consumer Forum, sitting judge. One more colleague is also here from District Forum. See, always this consent, just like it is, in matches we say opening, striker of the ball or the opener. For any procedure, this topic is your opener. In medical field we are talking now, even though it is under Indian Contract Act. But we are purely talking of a patient and a doctor and a RMP relationship. So we'll just give you a brief, and instead of going in more theories, where practical applicability and where we can make this consent as your savior when you practice in your medicine. That is important as an registered medical practitioner for us. So it is under Indian Contract Act. It's so simple, two people has to agree on same sense. See, in definition of all forensic subject, which we teach in medical college forensic, and we were taught by our forensic people, it says that it should be at the same sense, practically not possible. At same level, and at the same time, and at the same date as per this Indian Contract Act, which is practically impossible. But what law presumes, it should be seen on your document. That is, see, I will give you a very simple example which has occurred we are from Municipal Medical College, one of the best medical college of this country also. Even the unit head makes this mistake. Consent is taken today, say 13th of March. A patient is to be operated on 14th of March in the OT, and they take consent on 13, and everything is of 13, time, nominees, witness, and you operate on 14th, say morning or afternoon, whatever it may be. So it cannot be, you cannot vouch for complete validity in the court of law. Undoubtedly for civil compensation is a different thing, and for criminalization of all this assault or negligence would be a different thing. So this is common, everyone does. की आमच्याकडे वेळ नाही, डॉक्टर फार सिनियर आहेत आणि युनिट हेडच्या अंडर 100 लोक असतात आणि युनिट हेड लवकर कोणाला भेटत नाही. पण when allegations are made, then you get entangled in all these legal formalities and appreciation of law, appreciation of evidence, मग law काय म्हणते, police station काय बोलते. So this all simple things we'll discuss in this. Now for the purpose of medical treatment, it is always the patient. Now see this last line what we are discussing, please keep this in mind. I should say, please imbibe in your mind when you practice this last line. What it states, consent is not an one-off event. I will repeat. It is not a one-off event of signature. म्हणजे आपण एक घेतली सही, त्याच्या नातेवाईकाची किंवा पेशंटची, आणि एक विटनेस ठेवला आपल्या सेफ्टीसाठी लिहून घेतलं, म्हणजे सगळं झालेलं नाही आहे कन्सेंट. What it states, but it is rather a process of communication. I will tell you, 15 years before, we were first at Sion Hospital to start. I was Sion till last 3 months, to start communication skills CME. When Dr. Sandhya Kamath was our dean. See, it is a part of your consent. And if you go through, sir was sitting for the Consumer Forum, and whatever practical knowledge I have of hundreds of cases, what we deal in medical colleges, if your communication with your patient is good, your 90% of allegations can be saved. Take it from me. काही नाही, फक्त 5 मिनिटं द्या पेशंटला, सिनियर डॉक्टर. मी नावं नाही घेऊ शकत किती मोठ्या डॉक्टरांची अशा केस आलते. Just because, the relatives, even in consumerism, sir will agree, if you go to corporate hospital and if I am paying for services of Sudhanshu Bhattacharya, I will not allow his RMO to check me. Why I should allow you? I am paying for Sudhanshu. Example. See, this is what law says. So please, communication take it as a part of your consent, and it would be the opening defense for you if there is any allegation in any court of law. Maybe civil courts or maybe criminal courts or maybe tribunals, जहाँ कहीं भी जा सकते. Now second line, we have 20 minutes, basically this slide is for 40 minutes, so we'll skip which is not practically important. See what it reflects the autonomy of each individual and the right of self-determination. See, in democracy, we all as a citizen of this country have fundamental rights. Everyone is enshrined with the fundamental rights, except in few conditions which cannot be vouched by that citizen of this country. But what it says, it is the autonomy of myself. Why this law is made? Otherwise, there is a trend in medical college, आज पण लिहितात गव्हर्नमेंट कॉलेजला कन्सेंटमध्ये की ह्याच्यात काही झालं तर डॉक्टरला जबाबदार धरणार नाही. दिस इज नॉट दी वे. लॉ डझंट accept you all these bullish things from you. And this goes against you to create a contradiction in your defense. See, basically in law and defense is of contradiction. Sir will agree with me. In criminal is a contradiction which gives you benefit of doubt. It is never a court will say ki he is not a culprit. He will say lack of evidence we are giving him the acquittal. You read hundreds of judgment, maybe Supreme Court, High Court, Session Court, or even your magistrate or taluka courts. So it is the autonomy of individual fundamental rights. Now absence of consent may constitute tort of battery. I think हे फार कमी लोकांना माहीत असेल. See, tort of battery is what? See this, why we say instead of filing a case in negligence, in few cases you can have battery of tort. Battery of tort is what? Simple. It is just invasion, a physical invasion with an intention of an offense on you. Just touching a patient. Now we are only in patient-doctor relationship. But this is a common law which can be applied between two persons. See, there are laws, there are doctrines also. So same. Now this what says, we'll read only one example. See, patient consents to the treatment without understanding the basic nature and purpose of the treatment. See, many a time or few of the times in court, even though you have taken a valid consent, documented consent, I will not say valid, because unless and until court agrees to it, is not a valid. It's a documented consent in primary stage, but the defense or the plaintiff's lawyer will always try to make it invalid. So one of the reasons cited is की सही घेतली पण त्याला समज नव्हती त्याची. So one of the criteria to make it as invalid is that if when XYZ gives a consent, maybe in any case, and if he is not in the state to understand the nature and the consequence of that act, so that consent becomes invalid in the court of law. So in this battery of tort, instead of filing in negligence, can see according to some authorities, battery action could be brought instead of negligence in the following situations. These are few situations, one of these we have discussed. Now why consent, individuality right is concerned. See, every human being of adult years and sound mind. See, sound mind is very important. And in law says that the person or the subject or your patient now in medical field is always, that consent is valid when he gives you a consent in a state of compos mentis. Compos mentis doesn't only mean a sound mind. It means a sound mind with a healthy body also. So composement has to be proved. Okay, when consent is given for the act, he was in that state of composement, is sound mind, so that he can give. See, I have given many thousands of evidence in the court. I'll give basic burn cases coming to our burns ward, and the doctors are saying it is 90% burn, 100% burn, whatever they may say. And upper limb 8% as per rule of 9% affected. And then you see in testimonial there is fingerprint. And then doctor is giving testimony that she is in the state of to talk and give statement and blah blah blah. See, where we contradict ourselves. See, always in law, मराठीत एक म्हणे आपल्या चुकांवर ते जगतात. If you don't make mistake na prosecution, you may take V.R. Manohar as a defense lawyer also. He cannot also give you acquittal. Always keep this in mind. Means this is my practical experience, whatever I have. Now, in medical emergency, we all know consent can be divulged. This case one we have cited is Aruna Balkrishnan versus Sony Hospital. See, that is established in an emergency. Don't wait for consent. These are few situations where without consent also a surgeon to save the life in good faith, that we are discussing in next few sections. We all know this. Now you know this, see, under 50, previously it was CRPC 53 Part A, now it is 52 BNSS. A person can be examined at the request of police by the use of force. Even law permits to use a reasonable force. Sorry, I failed to add reasonable force. It has to be a reasonable force. So don't fear of law. Now what I have seen in my last 28 years, I am teaching forensic medicine from 97. And I have done more than 50,000 postmortems as of now. I was first to start this one-stop crisis center of this country. And I was one of the resource person to enact POXO Act in this country. Doctors have fear of law. From my practical experience and citations and what law has been made by this country, except few sections, law is for doctors, not against them. Always keep this in mind. That is the reason conviction of medical fraternity is near to nil if you compare with other offenses. Same offense, say I am talking of previous 304 part, A part. Same was for the accident by a truck driver. Their conviction rate is 10 times higher than the same case filed against for the alleged gross negligence of a registered medical practitioner. Don't fear of law. It's just comparison in BNS, and we all know in this. See, I'll just cite, see what communication, miscommunication leading to violence against doctor in mostly in government hospitals. They are affected rather than private hospital because of workload. See, a doctor examining 150 patients a day in OPD cannot explain, cannot give 5 minutes, 10 minutes, which is given in a corporate or a private hospital where a doctor will examine hardly 20 or 30 patients in 24 hours. So, communication in good faith is also not an offense if you properly give your justification. So these are all exclusion of act which are offense independently of harm cause. Act to which a person is compelled by threat. Act causing slight harm can also be justified. So these are just comparison, will not go in detail. We also know in earlier 90, now BNSS 28 BNS says, now what is this? See, 12 years now. This is again a confusion. In our printed medico-legal document by government also, maybe by competent authorities, there is always consent. Below 12 years, an unsound mind. 2 days before only I was cross-examined in principal court only for this. Of unsound mind, we should take from legal hair and blah and blah. See what it says, who is conscious, mentally sound, and is of above 12 years of age. So we just only go by age criteria. That is not the only way. Why I am giving you 2 days before case? That case was examined by me of a Dadar school where only deaf and dumb were admitted. Now what has happened? Even though they are more than 12 years, I took consent of the legal heir or the custodian. If the legal heirs are not available, custodian has to be there. Now I was crossed by one of the good counsel. More than 12 years, you should have taken the patient himself or herself signature. I told him, dumb and deaf, the school is there. Dumb and deaf is one of the criteria of the mental disability, which certificate we give through medical board. So these females were mentally not sound for me. So I took consent of the legal heirs. So this has to be interpreted in a proper way. Then we can be on the right track when we are released. This we all know that it should be voluntary. They should have capacity, and these are various types of consent. Implied, express, that no need to explain, everyone can explain. What is more now, this is something called as proxy consent. Now sir can guide us in this if anything more is required. Proxy consent is, what it says, all about type of consent can take shape of proxy consent. It is just like a loco parentis, in short. If you compare, students staying in hostel, parents cannot be available. So the dean, principal or medical superintendent or the warden of the hostel can be loco parentis, can give a proxy consent. So don't fear of giving a proxy consent. Law is there to save you. Don't fear of law for this. Do your act in good faith. No one will be punished by the law. And separate consent is required for transfusions, separate surgeries for anesthesia. Now, something about blanket consent, Stop, this is my personal opinion, please. Don't take it personally. Many surgeons I hear. Please don't take blanket consent. It cannot be justified. I am taking consent for, say, partial hysterectomy. One example I am giving. And suddenly when I open the abdomen, the Pandora's box, and I feel I need to remove ovary also now. I feel I need to remove fallopian tube. निकाल दो ना, blanket consent है ना. नहीं होता है, please. It is against the fundamental right of that citizen. He is a citizen first of this country. And you cannot breach a fundamental right unless and until that act is done in good faith to save the life. Sometimes we open the abdomen, we may get heavy bleeding, which is undiagnosed. And if you don't suture or you take a corrective measure, that patient may die off. And in that time, you may not have time to go outside OT, counsel the legal heirs of this and take a signature, then it is justified. But just taking a blanket, हमने सब ले लिया है कागज पे, चलो जो करना है कर लेंगे. So please don't do this, and that cannot be justified, please. Now this, we all know informed consent. Will not, these are few examples. The citations, I think sir will also take few citations on this. So I will not go in detail about emergency. Now this is what informed refusal. ही एक स्टाइल झालेली आता. I don't know, in government hospital also. थोडं काही नाही बोललं, if he is not agreeing, take informed, negative consent, take informed refusal. When this is valid, when you exhaust all your attempts to take a consent, then you have to take this. See, in one-stop crisis center, FOXO Act is now, we know, is a special act. And any female less than 18 years, we have to file the case. And it is mandatory. Still that section 21 which is debated is in Supreme Court. Let Honorable Court takes their own call. But नाही देत का? ऐकत नाही? घ्या negative consent. This should not be the way. You counsel your patient first. Appoint counselor to do. We have done in sign 24/7 and 70% of the negative consent we have converted into positive. See, our aim should not be to deny the examination. Our aim should be to examine our victim in, say, FOXO cases. Because unless and until you examine and you certify your opinion, that cannot add to the value of conviction against the accused. That will be a benefit of doubt to your accused. Always keep this in mind. And that would be sufficient to say that we have good contradiction and you give acquittal to our accused. So these are all case laws. Now Samira Kaulin, everyone knows all this. Next resource person may also take this. Now this is real, valid, informed. Always try to take informed consent. Whatever may be your minor case, you may do minor procedure also. Don't take, support of implied and proxy consents. If it is feasible, please take informed consent. And over and above that, I will say, always take with full disclosure rather than semi-disclosure. Why you are giving your neck to your the plaintiff? I don't know, means why we have this habit? पूर्ण सांगून टाका ना, काय व्हायचं ते होऊ द्या ना. Why we are, means I don't know, except in few HIV cases where there can be some suicidal tendencies or danger of life to the relative. Explain everything. क्या जो adversity explain कर दो उसको. If he is ready, he will do. If he is not ready, don't do him. Simple है. So this is common consent, disclosure of information in Sandbury case. And thank you for this, your patient hearing.